Hello, everyone. So for our last lecture topic we're going to be talking about what happens between arrest and trial, and touching on both traditional and non-traditional prosecutions. So I'm going to split this into two, and this first part will cover sort of traditional trials and issues up until the trial. So we'll start by talking about traditional prosecution. So many criminal cases are simply dropped or dismissed for lack of evidence or other difficulties that prosecutors perceive in the case. For the vast majority of people charged with crimes and not fortunate enough to actually have the charges dropped, plea bargains, not trials, resolve the case. So plea bargaining is a process in which a defendant agrees to plead guilty in exchange for some concession for the prosecutor. So it may be a reduction in the type of charge, a reduction in the number of charges, or a reduction in the recommended sentence. By pleading guilty, the defendant gives up the right to a trial. Most civil cases are resolved outside of court without a trial in a process called settlement negotiation. So, what happens if you commit a crime? If the police believe that the suspect committed a crime, they will probably arrest the suspect. Charging is done by the prosecuting attorney, and it implies a formal decision to continue with the prosecution. And that's made by that prosecuting attorney, not by the police. The initial appearance, the Fourth Amendment to the U.S. Constitution requires that any person arrested be brought before a judge within 48 hours of arrest. The judge reviews the evidence summarized by the prosecutor and determines whether there is actually anything there, essentially, a reason to believe that the suspect actually committed the crimes that they are charged with. The judge will inform defendants of the charges against them, and they will also inform them of their constitutional rights. They will review the issue of bail, and they will appoint attorneys for those who cannot afford them. And again, due to the Fourth Amendment, they can be brought before the judge within 48 hours. So this is pretty quick. So in terms of the next steps, there's the preliminary hearing. So here the prosecution must offer some evidence on every element of the crime charged, and the judge must decide whether the evidence is sufficient to pursue the case further. No jury is present, and defendants rarely testify or offer any evidence of their own. The judge will sometimes send the case to a grand jury or reduce the charges, either because he or she believes the evidence does not support the level of crime charged by the prosecutor, or because of some sort of plea bargain. A grand jury consists of citizens drawn from the community. They meet in private with the prosecutor to investigate criminal activity and return indictments, which are complaints prepared by the prosecutor describing the crime charged. The grand jury may call witnesses if it is dissatisfied with the witnesses presented by the prosecutor. In some states, the defendant does have the right to testify as part of the grand jury, and in about a third of states, a criminal defendant cannot be prosecuted unless a grand jury has found grounds to do so. The remaining states permit the prosecutor to proceed either by grand jury indictment or by some sort of preliminary hearing. If the grand jury decides there is sufficient evidence to justify the defendant being tried, then it issues the indictment. Next is the arraignment. Here, the judge makes sure that the defendant has an attorney. The defendant is asked to plead guilty or not guilty. It's customary for defendants to plead not guilty at this time in order to provide opportunities for both discovery and for plea bargaining. So discovery is the next step. This is where the defendant's attorney can review some of the evidence against the defendant. And this is done in civil cases. Each side is entitled to discovery. Each side can question the other side's witnesses and review documents that the other side might use at the trial. In criminal cases, what the prosecution must reveal to the defense actually varies. Most states require that only the prosecutor shared evidence that is exculpatory. So evidence that tends to show the defendant is not guilty or suggests that the prosecution witnesses are not credible. In many states, the defense is required to notify the prosecution if it intends to rely on insanity or some sort of alibi defense. During the discovery phase of the case, both sides can file pretrial motions seeking favorable rulings on the admissibility of evidence, such as a motion for separate trials for the different charges, a motion to sever counts, a motion for change of venue if they think that that person's not going to get a fair trial where they are, motion to suppress a confession or other statement by the defendant, and motions in limine, a request for some sort of pretrial ruling. The other thing that becomes really important here is bail. So judges must decide whether to keep criminal defendants in custody between arrest and trial, or whether to release them with a promise to reappear at later hearings. So they have to show up for their court date. Judges can deny bail. Usually they do this if the defendant is a flight risk or if they think that they are a risk or a threat to the community. They can require that money be deposited with the court. This can be done by the defendant, their family, by a bail bondsman as well. These are sometimes colloquially referred to as bounty hunters, because if you skip your court date, they will come and track you down because you used their money. And they can also require that a third person be responsible for the defendant's future appearances. That person will have to forfeit money if the defendant doesn't appear. So again, this could be a family member or a bail bondsman. In addition to ensuring that the defendant's return to court, bail has a secondary purpose, protecting public safety. Bail decisions are influenced by both legal factors, like the seriousness of the offense, and extra legal factors, such as the defendant's race and gender. So for legal factors, research has shown that bail is likely to be denied or set very high when the offense was serious and when the defendant has prior convictions. In terms of extra legal factors, race and gender have been shown to have significant impacts on judges' pretrial release decisions. For example, Black defendants were less likely than other defendants to be released, and female defendants were assigned lower bail amounts than males. Judges tend to use a mental shortcut called a matching heuristic when determining whether bail should be allowed. So they search through a subset of available case information and then make a decision on the basis of only a small number of factors, such as offense severity and prior record, which often results in them ignoring other seemingly relevant information. So does pretrial release actually affect a trial outcome? Yes, actually. Defendants who are detained in jail and are more likely to plead guilty or be convicted and receive longer sentences than those can afford bail, even when the seriousness of their offenses and the evidence against them are the same. Can high-risk defendants be identified? This goes back to that risk assessment we've talked about before. So around 1970, a push began for legislation that would increase the use of preventative detention of accused persons who pose a risk of flight or dangerousness to the community. This assumes that valid assessments of risk and accurate predictions of future dangerous conduct can be made, and that assumption isn't always correct, as we talked about previously with risk assessment. All right, so the next thing that we are going to touch on is pretrial publicity. So there's some conflicting constitutional rights here. So the First Amendment allows the press to inform the public about criminal investigations. The Sixth Amendment, on the other hand, concerns the right to a speedy public trial before an impartial jury. A common problem that occurs when local media and internet sources disseminate pretrial information, like the defendant's criminal history, other things along that, it's exceedingly difficult to disregard that information once you've heard it. And then if you're called as a member of the jury, now you are sort of biased in this particular case. There have been some legal rulings on pretrial publicity. So Redoux v. Louisiana The court decided that exposure to news with information strongly pointing to the defendant's guilt was actually a violation of due process. Nebraska Press Association v. Stewart, the court ruled that a trial judge could not order the press to refrain from publishing information likely to be prejudicial to a defendant, and for example, a gag order, unless the defendant would otherwise be denied a fair trial. So again, that comes back up. Richmond Newspapers, Inc. v. Virginia, the press cannot be barred from attending and reporting a trial because the First Amendment guarantees public access to criminal trials. Ganetco v. DePasquale, the press can be excluded from pretrial hearings in which potentially prejudicial material might be an issue. And then Moomin v. Virginia, the court held that defendants do not have a constitutional right to ask prospective jurors about the specifics of their exposure to pretrial publicity. So a little bit of a mixed bag there. Now, psychologists have helped to try to see what effects these things do have by looking at pretrial publicity with basic psychological science. So there have been two types of studies. In experimental studies, participants are first exposed or not exposed in the control group to some form of publicity and then are asked to assume the role of jurors in a simulated trial. Researchers measure the impact of publicity on decision making. So these studies have shown that pretrial publicity does affect jurors' evaluations of the defendant's character, the extent to which they like or sympathize with the defendant, their pretrial thoughts about the defendant's guilt, and their final verdicts. So why is that? Pretrial publicity may bias jurors' interpretation of evidence presented at trial. Also, jurors can believe incorrectly that the pretrial information was actually presented as part of the evidence at trial. This is called a source monitoring error. I heard it, so it must have been part of the trial, even though it wasn't. Presentation of publicity via television has been found to have a greater biasing impact than the same information when it is presented in print. But the combined effects of TV and newspaper publicity have had the greatest effect overall. You're getting it more places. Participants are generally unaware that their opinions have been biased by this material. Case-specific information, specific pretrial publicity made available prior to trial can affect the sentiments of juror in that particular trial. And then mock jurors can also be influenced by generic prejudice, the prejudice arising from media coverage of issues not specifically related to a particular case, but thematically relevant to the issues at hand. Tort reform, racial and ethnic stereotypes, I would imagine a lot of the recent media coverage about police brutality, for example. In field studies, respondents are surveyed to assess the effects of publicity about a particular real-life case, so not a hypothetical case, an actual case going on. So by polling people exposed to reports of actual crimes, researchers, so for example, Studebaker et al. In 2002, have found that people exposed to pretrial publicity possess more knowledge about the events in question, are more likely to have prejudiced the case or prejudged the case already, are more knowledgeable about incriminating facts than would be that would be not admissible during the actual trial itself. Both types of studies reveal that jurors may be adversely affected by pretrial publicity. So how do we remedy this? You can do what's called a continuance, where you postpone the trial. You can have an expanded voir dire and try to weed out those people who have really been exposed pre-trial. You can give very strict judicial instructions to ignore anything you saw pre-trial. Unfortunately, research suggests that these first three are really ineffective. They just don't work at all. You're still going to have biased jurors. And then the one that works is the change of venue. And this is preferred by social scientists based on the research. You get that person to be tried at a venue outside of their local municipality where that's been covered. That's the most likely to give them a fair trial, a fair shake in this instance. Now, let's talk some more about plea bargaining. So most criminal cases, 90 to 95%, end prior to trial with a plea bargain. The defendant pleads guilty to some charge in exchange for, again, some sort of concession, like a reduction in charge or reduction in sentence. In charge bargaining, the prosecutor drops some of the charges in return for a guilty plea. As a result, prosecutors often overcharge to be in a good position to do this. A little bit sketchy maybe, right? But that's sort of how the system works. Plea bargaining may also take the form of sentence bargaining, in which prosecutors recommend reduced sentences in return for guilty pleas. In general, judges will follow the sentences recommended by the prosecutor, but there's no real guarantee the judge is still going to make that decision. So why do defendants plead guilty? Because of the likelihood of conviction, probably pretty high. The other is that because if they were convicted, they would face lengthy sentences. There we go. Why do prosecutors plea bargain? To dispose of cases in which the evidence against the defendant is weak or the defense attorney is a formidable foe. Basically to ensure a win in that scenario. To obtain the testimony of one defendant against a more culpable defendant. Hey, we'll give you a lesser charge if you'll testify against the big guy in this particular drug ring. And to expedite the flow of cases. If you can imagine how much longer the judicial process would take if this other 95% all had to go through trial. So what are the psychological influences on the process of plea bargaining? Well, there's framing effects. The way that decision alternatives are framed as either gains or losses can have an impact on a person's choice. Individuals are more likely to take chances when the decision alternatives are presented in terms of gains rather than losses. That just makes sense, right? We want to look out for ourselves. Then there's the overconfidence bias. People tend to be too optimistic about their chances of securing a favorable outcome. So, what are the evaluations of plea bargaining? Advocates cite several justifications for plea bargaining. Pleas relieve the backlog of cases. They facilitate prosecution of other offenders. The absence of a trial reduces involvement of various criminal justice personnel. Critics cite the following justifications for plea bargaining. Improper sentences. Sometimes they are too harsh, but more often they're too lenient. The process encourages defendants to surrender their constitutional rights, so some people understandably have a problem with that. Some people believe this gives prosecutors too much power, and innocent defendants might be coerced to plead guilty, so they get a lesser charge, a lesser sentence. Now, how about settlements in civil cases? This is sort of our last step before an actual trial. The vast majority of civil disputes are resolved without a trial, again, in the settlement negotiation that we've talked about. And that's private negotiations between the attorneys representing the disputing parties. The legal merits of the case are really what matters most here. Outcomes are also influenced by the negotiator's reservation price. The defense's reservation price is the maximum amount of money he or she would be willing to pay in order to reach an agreement. The plaintiff's reservation price is the minimum amount of money that he or she would be willing to accept to settle the claim. In considering the merits of the case, plaintiffs, defendants, and attorneys are often influenced by heuristics or psychological biases. So the self-serving bias occurs when people interpret information or make decisions in ways that are consistent with their own interests rather than in an objective fashion. So parties often have difficulty seeing the other side, not surprisingly. The anchoring and adjustment bias occurs when negotiators are strongly influenced or anchored by an initial starting value and do not significantly or sufficiently adjust their judgments away from that starting point. So the higher the first offer, the higher the ultimate settlement. All right, so I'm going to cover what actually happens during a trial in the second video for this week.